You're recording.
Good evening. I'll call this March 26th, 2024 Fairfield Plan and Zoning Commission to order. Start with our meeting minutes from March 12th, 2024. I have a motion on the item. Commissioner Harrison,
I'd like to make a motion to adopt the meeting minutes of the 12th, March 12th meeting.
motion to adopt, motion to approve, is there a second? Second. Second, Commissioner Collins. Well, I mean, if he's not it, you're gonna be sitting in on Berkeley, but you're not up to speed with full minutes of 2020.
Oh, okay.
So,
I mean, I was there for about 3/4 of it.
no, I know it, but let's look, Commissioner Siebert staying for everything but Berkeley. Commissioner Corsillo seconds. Commissioner Harrison.
Yes. No changes. I feel good. We missed you, Mr. One, at the last meeting, but glad that you're back.
Be back, and thank you that was missed, but I doubt that it was missed that much because there's capable, you were in capable hands.
Double duty.
Commissioner Corsillo,
No comments.
any other comments or questions? Being none, we'll put this to a vote. All those in favor, please say aye or raise your hand. Passes unanimously. Next item is 277-301. Oh, yeah, Commissioner Ford is virtual.
Yes,
Well, he has to recuse himself anyways with this next one, so.
I don't see him virtually.
All right, let's move on. This next one, we'll worry about it. Proposed settlement of litigation between the Town Plan and Zoning Commission and Berkeley Road LLC, whereby Town Plan and Zoning Commission will consider stipulating to approving the zoning compliance application for a 40-unit residential development pursuant to section 830G of the general statutes. Such settlement is subject to court approval. Commission will offer the opportunity for public comment on this proposed settlement. So I will, in lieu of a staff presentation, in light of the fact that it's in litigation, I decided to do this. Staff.
I'm having trouble hearing you.
Sure. Considering the settlement, considering the ongoing litigation, instead of having staff do the comments, I'm going to give a quick summary of where we are. So we heard this application last year in June or so. There was a denial of the application. It's a 4-3 split. The denial is part of the record, or at least has been made public. The original plan was 40 units at 30% affordability, which is 12 units. After our denial, there was an appeal in the Superior Court, and that led to negotiations with the applicants. So let me give at least some history as to where the negotiations went. I won't give all the negotiations, there's really more of the pertinent ones towards the end. There was an offer in early January to reduce the unit count from 40 units to 35 units at 15 affordable units, which is 6. There was another offer that was rejected. There was another offer made on 125 in late January, a full story reduction from 40 units to 30 units with 15 affordable units, which is 5, comprised of 2 studios and 3 one-bedrooms, all at 80% AMI. They would also wanted to add a small ground floor storage and laundry room, which would eliminate 2 below building parking spaces. Resulting ratio would be 49 spaces for 30 units, or 1.6 per unit. And the original plan was 1.28 per unit. That was rejected. The last offer. So in addition to what I just previously said, one story less, 30 units, 15% affordable, 2 studios, 3 one-bedrooms at 81%, at 80% AMI. They agreed to add a 6th affordable unit to achieve 20% affordable among the 30 units at 80% AMI. That offer was rejected with a counter from this commission that there would be four 1-bedroom units, 2 studio units. My bad. Sorry. That offer was not accepted, excuse me, and the commission countered with 6 below market rate units at 60% AMI. The applicant rejected the idea and reported further that they would not consider increasing the number of units offered at 60% AMI. Again, their last offer was 20% affordable among 30 units at 80% AMI only. So the options considered by this board are essentially one of 3, though we have noticed it for a rescission of the denial. We can continue with the appeal. However, when talking with our town attorney during executive sessions, which are private sessions for attorney-client privilege purposes, when discussing the merits of the appeal, the consensus of the commission was, in light of that discussion and the opinion of our town council, not to continue with the appeal. That's option 1. Option 2 is to settle or to pursue a settlement based on their last offer. And the third option, which is what at least was noticed tonight for a variety of reasons, but the simple being that we can, that the third option is rescission of the denial, which is, again, what's been noticed tonight, that we can discuss any 3 of those options, any 3 of the options that I have outlined. I would be mindful that in our discussions, I will get a motion on the table in a second that we can certainly talk as we wish. I would just be mindful. We do have some confidential conversations with attorney-client privilege. I'd be mindful about talking about the substance of those discussions. Attorney Baldwin is here to talk procedure and answer any other questions you may have. But I think that is a decent summary of where we are. Mr. Wentz, Mr. Baldwin, anything that I missed? Commissioner Ford, can you hear us? Are we coming through now? Commissioner Ford, can you hear us? I just want to make sure that we're being broadcast properly. Attorney Fallon, can you hear us?
Yes, Mr. Chairman, I can. Can you hear
Thank
me?
you.
Yeah.
I can hear you. Thank you.
Thank you.
Are we recording?
Yes, we are.
So let me see if I can get it right this time. The last offer was 1 floor knocked off, 30 units, 20% affordable, 4 1-bedroom units, 2 studio units, 1 studio at 60% AMI, remaining 5 at 80% AMI.
The laundry room.
And the
So the laundry room.
lower level addition with a storage and laundry room that eliminates 2 parking spaces.
Let's get a motion on the table and we can have this discussion. Commissioner Corsillo,
Move to rescind the previous denial.
or second? Second, Commissioner Lely. Commissioner Corsillo,
Point of order.
sure.
I don't think this is properly noticed as a rescission. I think it's our tradition as a commission to really put out the information to the public, and I don't think we have. I don't think the public has had the right time to digest these options that we've had in front of us. Our commission's practice is to really properly notice items on the agenda, and I don't think we have in this case. This is not a settlement. This is a rescission, and it's not been properly noticed. I would like us to withdraw this from the agenda tonight and take it up at a date certain when we have properly noticed it and the public can take in all the information that's been available. I think it's misleading to say this is a settlement that's inaccurate. It's a rescission of our decision from June 2023.
Second that?
No,
It's a point of order. You can't talk on that.
Okay.
I'm not sure that I agree with that point of order. You can discuss
Can I
it.
ask Mr. Baldwin for an opinion on this?
No. Commissioner Corsillo, go ahead.
Then I'd like to make
You
a
can
point.
ask it at your time, Commissioner. Seriously. It's his turn right now. If you want to make your motion,
Can I ask everyone to speak up a little because we don't have mics?
The point of order, I'd like clarification. I don't think you've given it to me as the chairman, and I would like that. I think the public deserves that.
You can ask it at your time.
I asked for a
I'm
point of
fine.
information, that this is my time. You can look at Robert's.
Commissioner Crusillo's turn is now. I recognize him. Thank you.
So I think there were really two questions before us. The first being whether or not to rescind the denial, and then the second being if we opt not to defend the appeal, whether we should pursue a settlement. So first, I want to speak to the question of whether we should defend against the applicant's appeal, which I think is the more straightforward of the two questions. This commission has an obligation to apply the law. In the case of 830G applications, the burden is on the town to demonstrate based on sufficient evidence in the record that denying the application is needed to protect substantial public interest in health or safety, and that such public interest clearly outweigh the need for affordable housing. I've been by the site many times. I've listened to and read all the testimony from neighbors, so I certainly understand public's feelings on the application. But the commission has to act dispassionately, and whether or not this development threatens public safety in reality, and it very well may, it's clear to me that the weight of the evidence in the record, which includes sign off from experts employed by the town, failed to demonstrate that. So in my view, it would be irresponsible to force the town to litigate a case that it appears all but certain to lose. On the question of whether or not we should pursue a settlement, we've heard from members of this commission, members of the public, refer to predatory developers that care only about profit and that take advantage of and benefit from 830G to do so. We know building and operating deed restricted below market rate units is less profitable than building and operating market rate homes. That's that's common sense. Otherwise, I think every development would be 100% below market rate. So a predatory developer seeking to maximize its profits without regard for the community is going to use any legal means available to skirt affordability requirements. And under 830G, if a developer wants to build taller and or denser than zoning allows, it must set aside 30% of homes it intends to build as affordable as a cost of building taller and or denser. If we allow just 15 or 20% affordability here, we're discounting the cost of building taller and or denser than zoning allows. And more importantly, we're telling the developer we're willing to do so. So if you're a predatory developer, you'd much rather build a 30-unit building with 6 homes set aside as affordable than a 40-unit building with 12 homes set aside as affordable. And if you're a predatory developer and you see this commission is willing not only to reject an 830G application without meeting the burden required by law to reject an 830G application, but also to then accept a settlement offer that allows you to build a residential development that is denser than zoning allows without having to set aside 30% as affordable, why would you ever propose a development that you think this commission would tolerate? If you're a predatory developer, the best way to achieve your goal of maximizing profits is to submit an 830G application for development that satisfies the statutory requirements for approval, but is so ugly and tall and dense, maybe even stories taller than what you really want to build, that this commission will reject it anyway and hand you an opportunity to propose a settlement that lets you shave off just a few units while cutting the number of homes that you have to set aside as affordable in half. Profit maximize, mission accomplished for that developer. So that's the precedent that we set if we accept what the developer has offered in this case, and without providing any meaningful relief to any of the neighbors who oppose this development. I think just this morning, I'm going to get their names wrong, Anthony and Paula Ursioli, who live at 238 Berkeley, wrote to the commission saying whether it's 20 or 30 or 40 units, the problems still remain. I mean, I happen to believe that most developers will not see this as a precedent and as an invitation. I believe the vast majority of developers are not predatory, but I believe they do exist. And if you believe predatory developers exist, the only conclusion you could logically draw is that they will see this precedent as an invitation and more developments like this will follow. So if you believe that we need more housing everywhere, I suspect you support rescinding this application, rescinding this denial rather, and refusing the proposed settlement. But this happens to be an instance where if you think there's too much development in places where it doesn't belong, you should also support rescinding this denial and refusing developers' proposed settlements. And that is what I will be voting to do.
I thought this was a point of order about an agenda item. Are we talking about the substance? I'm sorry to
Making a
interrupt.
motion. He made a motion.
No, I didn't hear his motion. What was his motion?
Motion to rescind the denial.
But you can make a motion in the middle of a point of order? Because
You
we're,
made the motion first.
pardon me,
You made the motion first.
but the point of order interrupts the motion, doesn't it?
Yes.
Are we supposed to be talking about the agenda item, whether it's
Right now, I have, listen,
noticed?
Commissioner Corsillo's turn is gone. He made the motion. We'll let Commissioner Levy go. And then Commissioner Harrison, I suspect, is going to want to jump in, and that's fine.
Thank you, Mr. Chairman. I concur with the statements by Commissioner Corsillo. I was present at the original hearing and reviewed the record and so forth. And there's no doubt in my mind that based on the record, there's insufficient basis for us to continue the litigation and oppose the appeal. The evidence is such, or there's no evidence that would support the town's burden of establishing that the threat to public health and safety outweighs the need for affordable housing in this case. And that's based upon the record and the testimony that was adduced at that time. As I said at the time, and in fact, I did in favor of this application at the time, even though recognizing and stating for the record that I thought it was a terrible development, that I thought it was oversized, it was not appropriate for the neighborhood, and that there were concerns about sightlines and so forth. I still felt that in order to fulfill this commission's obligation to rule in accordance with the law of the state of Connecticut, particularly 830G, that I had no choice but to support this application. With respect to the various proposals to settle, that would set, to my mind, a precedent that we should not endorse. It would allow predatory developers to routinely come in with something far larger than anybody would ever consider reasonable, with a hope that they would then be able to go negotiate down and, for instance, put in a massive overdevelopment with 20% rather than 30%. And finally, I question whether or not this commission even has authority to negotiate for a lesser number than the 40 units, let's say 30 and so forth. And we had the opinion last week from a Superior Court judge who basically said that the court's interest or the party's interest in settling a dispute cannot subvert the zoning regulations of the town and allow a special privilege to one of the parties. And if we were to go with one of the settlement proposals, basically, we would be conferring a special right or privilege to this developer, which I do not think the court would sustain. Now, granted, it's a Superior Court opinion, but Judge Radcliffe has been ruling in these areas for many years, and his opinions carry a great deal of weight. So based upon that, whether we view it as a rescission of our prior denial, or if, as noticed, we're considering stipulating to approve the application for a 40-unit residential development, they're the same thing. Thank you.
Commissioner Harrison.
Thank you. Just so point of order, a rescission is on the table. Is that, Harris? That was motion Mr. Corsillo made? Does
So
that-
we need a ruling?
The motion on the table, if it's rescission, if it's just semantics we're dealing with, fine. But the motion is rescission based on what could be a stipulation to approve 40-unit development of the application.
Okay.
So if your concern is just simply the word rescission, I will recommend or suggest that we tailor it to the language here. I think Commissioner Levy is correct. That's the same thing. Disagree with that?
I would, may I finish?
Well,
Okay. I
I
just,
finished,
I
now
wasn't
you
I
can-
wasn't
now
trying
you
to
can
go back
start,
to
yeah.
the chairman.
No.
Yeah, I just wanted to be clear. Yes, a rescission is on the table, and according to Robert's rules, I think this commission needs to be aware we would need a 2/3 vote because the rescission was not noticed in the agenda. So under Robert's rules, rescission would require a 2/3
So
vote.
you see a difference between a rescission of our denial with a proposed settlement to stipulate to approve the zoning application.
I think a rescission is much different, and I would lean on
Okay.
our town attorney to certify that. But I think Robert's rules is very clear, and we follow Robert's rules, and this commission, we would need 2/3 vote.
I think it's a semantic argument, but let's ask Commissioner Porcillo and Commissioner Levy if they would consider amending their motion to, instead of use the word rescission, but to approve the stipulation, to empower our town attorney to approve a stipulation to approve the zoning compliance application of Berkeley Road LLC for a 40-unit development pursuant to section 830J.
Yeah, I'm happy to amend the language to make the motion to stipulate to approve the zoning compliance application for a 40-unit residential development pursuant to section 830G of the Connecticut General Statutes.
Commissioner Levy?
I second that.
Again, this is a rescission. This is going back to the original offer. It was not properly noticed as a rescission. I'm going to stand by Robert's rules, kind of the guidebook that we all follow, and the rescission would require a 2/3 vote. I think it would be illegal to keep pursuing it.
I could agree, considering I think it's just, you're talking semantics.
Mr. Baldwin, can you offer? can you
Mr.
comment on
Baldwin?
this?
The only thing I would offer is that this is the prerogative of the chair to rule on your point of order. It's not mine. So I understand his distinction or the suggestion that there is no real distinction between the two. And your point of order is decided by the chair.
What?
I haven't said anything yet. Can I just?
No, that's fine. I'm gonna, you can be up next, absolutely. Anything further, Commissioner Harrison, in light of motion?
No, I
The
think
amended motion to reflect the semantics that you,
I would disagree with you respectfully, and I think this is a rescission. It should have been properly noticed as such, and I think it would be illegal to continue.
let me ask,
Not rewording it.
okay, if you can give me a distinction between the two, I would certainly consider it, but I've yet to hear one, so.
Thank you for the time.
May I ask a question? Because I don't know what's going on. Did we just have an amendment to the original motion or to something to add rescission to the agenda, or did we not?
No, the motion, the motion has been amended because there was a point of order saying that because the word rescinded was used instead of the language in the notice, the motion was amended to reflect language in the notice. I believe that the first motion and the amended motion are the same thing. But out of caution, I asked for the amendment to be made to reflect what the language in the notice is, the agenda is. So now the motion is to approve settlements, to approve a stipulation, to approve the zoning compliance application or 40-unit residential development pursuant to 830G of the Connecticut statutes.
I think the consensus is a rescission, right? He's just conforming his motion to how the agenda is worded.
I would think it's a distinction without a meaning. Whether it's rescission or whether it's a language in the agenda. It's a distinction without a meaning.
Yeah, I think the issue is for transparency. The agenda should have said rescinded. People would have known rescinding it is kind of confusing how it's worded. I agree. It does mean the same thing. What we're doing if we with this is rescinded. But I have another question. There's 3 items that we're discussing, but none of those were on the agenda. The word rescission wasn't, the word settling on another basis wasn't, and also the other option of continuing with the court. None of those are on the agenda. Is that adequate notice to the public? I mean, we have 3 options we're talking about. I'm not an expert.
Is it on the agenda? I didn't see it.
Let me, if I may.
Go ahead.
This language is the exact language that's been used by this commission in the past, specifically when the commission stipulated to a settlement of 50 Campfield Drive, where in my opinion, it's clear that what you're considering is whether or not to stipulate an approval of the application. Now, that's the most, severe, if you want to, outcome.
Yeah.
So if after discussion, you decide to settle for a smaller development, that's a lesser impact than what the notice calls for. The notice is considering, for the lack of a better term, the worst case scenario, if you will, from certain points of view, that it's going to be an approval of the 40-unit development. After discussion, there's an approval of the commission to do less than 40 units, that notice is covered. If you said, hey, we're going to settle at 30 units, and you, after discussion, decide, no, we're going to reject that and approve the original development, then you would have had to renotice it. But to notice it in this fashion covers that base. But it's consistent with how this has been dealt with in the past. It says this is 2 or 3 times where that's been done, and we pulled the language specifically from the Campfield Drive application, whereby the commission stipulated to an approval of that prior application.
I was here for Campfield. I don't recall that
No,
one.
you were not. That was-
93G,
What's that?
93G as well.
So it's the same agenda item, obviously different project, but noticed in the exact same fashion. So in my opinion, it's clear that what's up for consideration is whether or not to stipulate to approving the application, and anything less than that result is permitted under the notice that's been provided.
I just find it well incomplete and perhaps misleading, although I agree it does state the most onerous of any result in
Right.
terms of the public anyway. So
Right. From a public notice standpoint, I think it's clear that you're considering potentially stipulating to approve the original application.
Listen, I mean, if I can, just one extra thing. This is how we have been used to putting out items and agendas like this. Now, we've been living kind of with this for a few months now, and these have been the options that we've been discussing. So I could easily in our remarks just have focused on this agenda item. But out of caution, out of completeness, out of, our normal practice of considering, as Mr. Wentz said, less items that are less than within the footprint of this application, why I went through the entire history. Now, if that was unclear or if that was confusing, then my apologies for that, but certainly not to this commission, as we've been living and discussing this for a few months now. So if anything, it was to be clear to the public as to what the options are. We follow the regular notice that we generally do. Could have just easily just gone with this and not mentioned the other items, but I think to do so is an injustice to the public to know what the options really are. Having said that, who's up? Commissioner Harrison.
Another question. I think the bigger injustice is the people who are sitting here and others, they've not been privy to that information until tonight. I don't know how anyone could take that in, digest it, and then we do have a public hearing, and thank you for that, but people can speak, but how can they make sense of this? You've said things rather quickly, and I think it's a service to the public to do this. I don't know why we can't wait 2 weeks, let them digest it, and they can come back. It's just really unfortunate. I don't think our commission has ever really worked like this.
Well, I don't know. Listen, we've always had applications like this, and we've made amendments to go within the footprint of it. So I don't know about that. Listen, we can go forward and just not even discuss the rest and just discuss this. This has been properly noticed. The reason it was properly noticed is because the consensus was somewhat leading towards this. So that's why it was noticed as this and not something else.
I don't know what can we talk about our executive session? Our closed executive sessions in this forum? I don't know, so I'm not.
Certainly can. But as I said, I'd be mindful of attorney-client privilege communications.
That's why I asked.
Commissioner Randolph.
Members of the public, thank you for attending. I know this is all a lot of confusing legalese. So let me just try to summarize what I've just heard to perhaps clarify things. Mr. Wendt has said that this has been properly noticed. It complies with other notifications. I think Commissioner Harrison is earnestly trying to determine whether there has been proper information going out to the public on this matter. So I think she's doing that in good faith. Attorney Baldwin is here to provide legal advice. He's deferred to our chairman, Commissioner Noonan, who is a qualified attorney. So my understanding, I'm not a lawyer, is that this is all operating correctly. So just as a context, I guess the more basic thing is I don't like this project. I'm not going to speak for other people, but we don't like this project. It doesn't match the character. It's too big. But a couple of things. The safety issues are the only reason we could deny this. And I'm new to this commission. My reading of the evidence, and I am experienced reading traffic engineering reports. I'm a registered architect and I work on other projects. The safety issues did not rise to the level that would allow us to deny the project. I know there's some other members of the commission who interpret things differently. They've relied upon non-expert witnesses, but the expert witnesses and the staff have said that there are not safety issues. That is the only way we could deny this without being sued and losing. We will likely, according to Attorney Baldwin, lose this case. We've already spent, I don't know how much money, a lot of money trying to uphold basically the earnest, but I think ultimately unsuccessful denial of this, because the state law says unless there's a safety issue, we can't deny it. Now, why is that? It's because we as a town, and I'm a new commissioner here and most of them are, we as a town haven't planned for affordable housing. We are below the state regulation. And unfortunately, too many people have said, not in my backyard, and it's ended up in your backyard. So as a town, we haven't planned, and we're trying to do better. And unfortunately, people said, not in my backyard, and it's now in your backyard. And legally, we don't have any recourse to this. We're going to lose. It's sued, and we're going to lose according to our attorney. So what can we do? We can continue with this appeal and lose. We can settle. And as Commissioner Corsillo has said, if we negotiate with these developers, we get a target on our back to now go in and propose some ridiculously large building, and Fairfield will come back and settle. And these things, there's a possibility that these will pop up in everybody's backyard because we have shown that we can compromise. It's a bad alternative, but that's why we don't want to compromise. The developer's already indicated he's going to compromise and come in with something. We don't have an agreement on what that is yet, but if we basically agree with their proposal, which we don't think is reasonable, then you'll be faced with something that's bad. We're already stuck with something that's bad. We could be stuck with something that's worse. I'm rambling a little bit, but I just want to let you know, I don't like this project, but what we're voting on is whether we can legally deny it. And the answer and advice from our counsel is that, the answer and advice from our counsel is that it'll be unlikely that we will succeed if we deny this in court. Please.
Mr. Chairman, may I just clarify
Go ahead, Attorney.
things? First of all, we're teetering on breaching the attorney-client privilege. And I think that it's important to give context as to how this came about. The fact is that we were presented by the plaintiffs in this case with a proposal. Now, anytime a settlement proposal or a compromise is proposed, it's the attorney's obligation to bring it to their client, that being this commission. That's what instigated this entire discussion, as everyone here knows, but maybe the public doesn't. And I don't want there to be the suggestion that it came from our office to the commission unilaterally without that initial proposal that set things into place and set forth the three options as you articulated them here tonight. And of course, the weight and the strength of a case is something that's discussed by the attorney with the commission, and that's happened in executive session. And based on those discussions, this hearing was noticed, and it's now in your hands to decide what to do with it.
Thank you, because I went through it, I think initially, but that is worth noting right off the bat that this, as you said, that this did not come from you from on high. This came from an offer from plaintiff, the applicant. Commissioner Harrison.
Thank you. Just going back to June 13th, I know it's been a while since we denied this application many months ago now. I just want to remind the commission of some statements that were made that night by Chairman Noonan. And I wish there was another way of helping this neighborhood. It involves a compromise between what the developer proposed and what the commission decided on in the decision of the underlying application. Commissioner Levy, I think that a reasonable accommodation could be made, which would be to reduce it by 1 floor, to reduce it by 10 units. That would then allow the proposed parking to be sufficient, but not impose a threat to the safe and health and welfare of the neighbors. We've had a good settlement offer. I think Mr. Fallon did it in good faith. He advocated well for his client, and I felt it was a good compromise. We got affordable units. We've scaled back. I think everybody kind of won. I just want to remember those words. For me, I voted against it. I can't trade in three units of affordability for the lives of people. This is about a safety issue. I think there was a lot of proof in that when we made our decision, a decision that was not made lightly, by the way. I think we also often get hung up in numbers, hue points, percentages, and we really forget about safety, and I don't think that can be ignored. I certainly won't ignore it. Thank you for the time.
Commissioner Collins.
I actually concur with Alexis on this, and in good conscience. I mean, I went to that Berkeley numerous times, and it is not a safe area. There's cars, large trucks parked there all the time, school children. I just, in good conscience, I just don't see that being, it's just a bad idea. And it's also, as she stated, that it is, well, some of our commissioners said we'd like to shave a floor. I think it was Commissioner Levy said, I'd like to take a floor off. Well, that was offered, but this settlement would actually, as bad as I think it is for that area, it takes 10 cars away from what were already, I think, too many cars. And it's scaled down. It's the floors off as the commissioner wanted. I mean, I think we should really think about that as opposed to just going back to square one and say, I mean, I don't understand. I don't think anything causes a precedent because every case is different. I mean, how does that, if somebody can answer that for me, how is that a precedent when there's developments in some other way, some other place? I mean, I don't get it. Can anybody answer that for me?
Of course, I've answered it in the past. The problem with the settlement is it is not seeking state law mandated 30%. It is seeking something less than that. It is and in all candidness, Attorney Baldwin, I'll let you speak quickly on the 20, if you can quickly, because I want, despite maybe the, insinuations earlier, not having the public know, I don't mind you saying about your opinion about whether a court will accept 20% affordability in a settlement offer. I think that's a procedural issue, right? So.
It is. It requires court approval, but I don't believe that would happen here, but it depends upon the judge. But
the judge could accept it or the judge couldn't accept it.
it's happened before, and there are reasons why it could be allowed.
Fair enough.
Just as there are reasons why a judge might take the opposite view.
I wanted that out there because we have the last 3 830Gs been presented with either a denial on Umpqua or a reduction on Beach Road, and then this denial here. Each time we have been approached by the developers with an offer for less density, less affordability as far as percentage. And I'm not sure off the top of my head all the numbers, but I mean, I think it's 20% has been kind of where everybody has been somewhat aiming towards. The state law for 830G is clear. Set-aside developments or these affordable housing developments need to be 30% in order to get out of local zoning regulations and get into that standard of, we need to prove that there's a substantial harm to health, welfare, safety, that outweighs the need for affordable housing. We don't have that here with this settlement. I think the references to Commissioner Levy saying shave a floor off included his belief that there should have been 30% affordability. Commissioner Levy, correct?
Correct.
Thank you.
We don't know. I mean,
Well, we know because he said it. And I know because we've been
he
part
said
of
it
the,
that night, yes, but he didn't
Yeah.
say that night.
no, I mean, he said it and that's what he meant. And he's been saying it for months now. So I don't, So was a precedent being set? It's kind of being set already now. Getting these 830G applications that are not fair to neighbors. It's been as clear as day for a while now. And these neighbors, as you said, are getting screwed by all accounts. We as a commission have to adhere to what the law is. And it's not easy being up here and saying it to people who are looking back at us saying, why are you doing this to us? Because it's heart-wrenching in a lot of ways. There's no doubt that I believe the neighbors when they say that the situation on the street is not even close to ideal. Unsafe, if you use that characterization, fine. Problem we have is that the record is full of our own experts in our own town saying it's good, the project will not create any unsafe aspects, not cause anything that's any more unsafe. The testimony given by the neighbor saying it's currently unsafe not help us to show whether this application will make it more unsafe to hit the standard that we need. There's been no credible evidence to that respect. Commissioner Brayman, when he at the time said it perfectly, I was saying that there's nothing in the record. His response simply was, unfortunately, the record says the project will be safe. And I know that runs contrary to what the neighbors say, and it runs contrary to what you go and you see at certain points in time. But we're bound by that record. And we go to the courts, that we're, my opinion is expecting a denial. My opinion is the court will reject our denial and we'll move forward with it. So the question is, and I say that because I voted against it. I voted for the application at the time. And to go through it, first you have to have that there's substantial harm. And as I said, evidence shows that there's not, that this won't cause any more. Sure, there is issues there now. Anybody who can eyes can see that. Evidence is that shows that it's not going to cause anything more to trigger the standard that we have to hit. And then whether it outweighs the need for affordable housing. Very vague idea that we got hit on Beach Road for. We cited 2 issues there, and the court avoided us on the sight line. And then with the other one, with the historic district, said it doesn't outweigh the need for affordable housing. And my research, at least in showing it and listening to other oral arguments, I don't know how the court's going to rule. I expect the court not to rule in our favor with respect to whether it outweighs the need for affordable housing. And then we had the issue of whether we can make a reasonable accommodation. If there are sightline issues, and the reasonable accommodation was getting parking off of at least the street next to the parking ingress and egress, which we didn't do. We didn't do any reasonable accommodations. So, I mean, that kind of went out the window with that respect. So there's no doubt that it was a well-intentioned denial, this application. But as I said at the time and now, it's not legally tenable. And we are somewhat setting a precedent Well, I'm not sure if we're setting a precedent. We're trying to avoid that, but we've got 3 of them in a row. We're getting this.
Evidence was incorrect.
So I'm, each one of these
That's
asked,
different. They're different.
stop.
Stop one.
We're talking amongst here, we're in public. So we are getting these offers consistently now. And it appears, we seem to be one of the few because some people I've been talking to, they've never, outside in Hartford and other practitioners, they've never heard of it. And I just can't support a settlement that doesn't have 30% affordability. I don't find that to be legally tenable. So that long-winded answer to your question, my apologies. Commissioner Braun.
I wrote up a statement, which I'd like to read. I might ad lib a little bit based on what I've heard. I want to concur with what Attorney Baldwin said completely. This is the settlement of a lawsuit, and there is no legal mandate that we must stick with 30%. So let me just read this to save time. I urge my fellow commissioners to accept the highest and best settlement offer on this project, which was put forth in good faith by the applicant. A comparison of the denied project with the compromise is as follows: from 40 to 30, from 4 stories over parking to 3 stories over parking. Although I believe, correct me if I'm wrong, it would appear as 3 from the road because of the slope of the property. Parking per unit would go up from 1.28 spaces to 1.63 spaces. Laundry and storage was not in the original, it would be in this, and that would also help minimize people driving around and exiting to do laundry, which is done on a daily basis by a lot of people. Affordable units, the original application was 12 because there was 40 and that was 30%. And that's a requirement in order to avail yourself of 8-30G. They must put 30% in.
Talk louder. I'm having trouble hearing you.
Pardon me?
Talk a little bit louder.
Sure. The compromise would be at 20%, 6 units. One of those would be at the lowest income level, 60% AMI, and 5 would be at 80% AMI. If we required the 30% that some commissioners would want, even with a scaled back development, it would be 9 units. So the way I look at it is we're really arguing over 3 units of affordable housing. We have a scaled back development, which would clearly make safety better because you'd have 10 fewer units and whatever cars are associated with those, less overflow parking, less trips in and out, et cetera. A compromise settlement is a voluntary agreement to resolve a conflict, with each side giving up something to get an acceptable outcome, with both assurance and not having to undergo the expense, time delays, and insecurity of continuing in court. This commission over 9 months ago voted to deny this project due to serious safety concerns regarding lack of sight line if parked cars are considered, narrow road that gets narrower in front of this project, no sidewalks, the road being a cut through, being a walking neighborhood with school children to seniors walking to school and to the store. It is a working class neighborhood without adequate driveways for existing residents, many of whom must park their work trucks and vans in the road on a consistent basis. And that is a basis that our town engineer has stated in the past is a valid reason for considering parked cars in a sightline analysis. We only disagree on whether that should have been applied here. It has been used before. There was also there were allegations of a sloppy traffic study, including timing of the study, use of national averages rather than town-specific data, failing to reflect narrowing of the road on the plans, or disclose vacant homes during the speed study, or the speed study, failure to show all the data, and failure to include parked cars. So now we're faced with a decision on whether to resolve the appeal by a compromise settlement or to continue with the court case. Both parties have something to lose by not settling. Either side could win or lose in court, and both would incur cost and delays and insecurity of knowing the outcome. It is true that according to the State Office of Legislative Research, almost 3/4 of all appeals on 8-30Gs go against the town. That is due to the unusual structure of the law, where the burden of proof is shifted to the agency, which is, I believe, the only instance in our state that allows that burden to be shifted. It's always on the appellant. The applicant, however, could still lose and would certainly delay and incur costs by continuing rather than settling, which is why we received a number of settlement offers, each one better than the last. Each one either increased the affordable percentage, well, the scale back stayed the same. It was going to go down by 25% from 40 to 30, but they kept upping the affordable percentage. And I'm not sure we ever went down. It seemed like it was kind of a one-way street with the applicant continuing to improve the offer. We have been presented now with a viable offer, which cuts the size of the project by 1/4 while still adding 6 affordable units, which is 20% of the total units, with 1 unit at the lower income level, on-site laundry, which would reduce trips. Overflow parking would be reduced as well, along with the traffic and pedestrian hazard it would create. It is not logical to reject a settlement offer by demanding a full 30% affordable. If so, no applicant would enter settlement discussion because they carry the entire cost of reducing the scale without receiving any benefit. But the reverse is also true. It is illogical to rescind our denial and thus approve the original 40-unit development. To do so would defeat the purpose of even holding the hearing, taking evidence, rendering a decision, and entertaining settlement offers. It would tell the public that hearings don't matter. No facts have changed since that decision was rendered. I would like to dispatch with several arguments in favor of rejecting the compromise. First, there is no legal mandate for the town to require the 30% in order to resolve an 8-30G appeal. Our town attorney has stated that. We have several other attorneys that are extremely experienced in 8-30G and land use, and they've come to us with settlement offers. I do not imagine they would have done that if they felt it was illegal or void. And it will be up to the judge. Judges have to approve, I believe, all land use appeals that want to settle, not just 8-30G. That percent is simply an amount imposed on developers to incentivize them to build developments that add affordable housing. Those who wish to maximize density to make up for the affordable units by having, market rate units, they have to put that 30% in there. And they also can avail themselves of the appeal law, where if they get denied or modified to a level they don't consider feasible, we have the burden of proof, which is the reverse. So that's why the 30% is there. It's what the legislature came up with to require them to do. And by the way, when they started that law, it was only 1%. I think that was 20%. They changed the law a few times. So I don't believe that. And I also, getting back to the purpose of 8-30G, there is no target of 10%. 10%, I met with the guy, one of the bureaucrats in Hartford that helped draft the law. I've been studying this for like 15 years. The 10% is not a target, although it's often treated as such. The 10% is simply an amount that enables a town to be exempt from the draconian and burdensome provisions of 8-30G. They basically wanted to exempt the large and the poor towns and cities from that onerous burden of having the burden of proof shifted to the town to defend their decisions. So they just picked 10%. That carved out about, 17% of all the towns and cities. And that percent has never changed, by the way. It's still around 83% of all the towns and cities that have never achieved 10%, because the big towns and cities had 10% because that's where they built it, because that's where it was needed. So that's not a target. We're not failing. We're adding hundreds of units all the time. And I think we should pat ourselves on the back for doing a good job and not feel that we're somehow guilty of not getting to 10%. We've been told by Mark Barnhart that we will not achieve 10% in our lifetimes. It will not happen. It's a mathematical impossibility. So let's just dispatch with that right now. It is unlikely that there would be a run on 8-30Gs. I disagree with the precedent argument, okay? Every parcel of land is unique. Every location is unique. Every group of neighbors is unique. Some get lawyers and experts and put a whole lot of evidence in the record. Some don't get as much, okay? Every development is different. It's simply not true that you can say this would set a precedent where everybody would come to Fairfield to build huge 8-30Gs. The fact that we might, somebody might say, oh, Fairfield settled this case, does not mean it would be settled in the future on the same basis. And we certainly do not want to sacrifice this neighborhood because of the speculation that on some future case, somebody might try to put something really big here that we don't like. That is not acceptable to me, to sacrifice this neighborhood. Settlement required about whether the court can approve or deny it. I've already covered it, but basically settlement requires court approval, but fear of a rejection should not be a concern over this commission's decision. It is simply not relevant. We must consider what we have before us. We have two well-represented litigants, the town and the applicant. It is not relevant what a court may or may not do, and we don't know what the court will do. They have to approve of any type of land use appeal that settles. The commissioners voted on June 13th, all expressed very deep reservations and concerns over density, size, traffic, parking hazards, lack of sidewalks, etc. some commented about the possibility of scaling back. Our decision was made 9 months ago based on the substantial evidence in the record on safety hazards. Some commissioners felt and continue to feel that that evidence would not withstand an 8-30 appeal. It certainly would withstand a regular appeal without the shifting of the burden of proof. This compromise alleviates the road hazard concerns while also adding affordable housing. Accepting the compromise offer is the only way to achieve the goals that all the commissioners that voted last time expressed. I urge the commission to do the right thing by this neighborhood and accept the compromise. We don't have sacrificial neighborhoods based on speculation. Please reconsider your thoughts and please do the right thing and accept the settlement proffered in good faith by this applicant.
To be clear, Commissioner Braun, the settlement was their last offer.
Yes, the one that I sort of listed I can email this to you if you want. I listed a comparison of them. I think Jim can, Mr. Wink.
But the last one being one less floor, 30 units, 20% affordable, 6 affordable, 1 60%.
Yeah, I think that's the best we can hope for in light of the structure of 8-30G. And I think a court, I believe a court would accept it based on the hazards that we've seen. We had one RTM rep come here and say she's been trying for 7 years to get a safety study. This predates anything. This is not NIMBYism. It's unsafe. I've been there several times. It's always filled with cars. And all the experts that from the town, I re-looked at everything they wrote. They never said this is safe. Bill Hurley, honestly, I couldn't really understand his report. All they said was this satisfies it, but basically they didn't look at parked cars. We did. We know it's not safe. The only question is what would a court do if it goes to the final hearing on the merits? But we have a settlement offer. We have the ability right now of satisfying everyone's concerns and scaling it back. To me, the only opposition and if the court finds it okay, let's do it. The only opposition would be, does it set a precedent? Is it legal? That's what a court will decide. And yeah, would there be a run on 8-30Gs? I don't think either of those are valid reasons to sacrifice this neighborhood, the safety of this neighborhood. And I'm not happy with 30 units. I think that's way too big, but it's an order of magnitude less. It's 25% smaller, right? Less overflow parking. Less cars going in and out. The laundry room, as I believe Commissioner Collins pointed out, I didn't want to sacrifice 2 spaces, but you're still getting 1.63 spaces per unit, where the original was 1.28. So it all goes to improve the safety, which is what this commission decided. So I just ask everyone to please reconsider. This is the best we can do. I call this a win-win in the world of 8-30G.
Thank you. Any other thoughts at this point, or should we turn to public comment? I guess after public comment normally is rebuttal, but obviously that just means that we'll have another chance to discuss this matter. And after that, we would adjourn and have the decision next time, like in our normal course. We're not going to make a decision tonight.
We vote on that in public, right?
Of course.
Oh, okay.
But it's not going to, just like any application, we hear everything now, we sit on it for the next hearing, just like any other application. Okay, so we have another chance to talk about it after public comments, and then actually another time after that when we decide. So I mean, it's funny, we made the motion. I guess we probably.
It's completely at your discretion.
No, I know, yeah, we started with the motion, but the anticipation was this to be more of like a public hearing, so I think I just, having this and not being a public hearing comments. Is everybody comfortable with what I just said going forward, even though we kind of have a motion present?
As long as we have the ability, any aspect, I mean, if I want to change it to accepting the settlement, do I have to file a motion to amend, or how would that?
What would happen is,
Is that next time, or?
I think, I mean, the point was to have this be like a regular public hearing, public comments and all that. So, I mean, I think I didn't help the cause, and I apologize for it because we were in the motion, in this area where we have, it's not in the public comment section because it's a litigation aspect, but what I had was, and I guess we'll have the hearing tonight, public comment tonight, rebuttal if we so choose, though we can probably wait till next time. and then make a decision. We'll have a chance to decide on it next time, obviously in public. Okay,
Thank you. Yeah.
Commissioner Harrison.
Yeah, thank you, Mr. Chairman. And I just had a question. I had some questions on the affordability plan related to this application. Should I save that for the next time? And
If you have questions, if they can answer, staff can answer now. If not,
Okay.
then we can certainly submit it and it can be discussed, or you have the time in between.
thank you. We can proceed with the.
You'll wait, okay, that's fine, yeah. Well, we turn to public comment then.
Question, if you don't mind. Is this the only and last time the public has in on this project? Zach,
I guess so the question, don't normally take questions from the public, but that's just fine.
oh, you opened it.
No, I understand
I
I'm opening it to public
have
now.
a question. Okay, let's get out of the way.
Yeah, let's. You can just,
My question stands.
you just have your name and address for the
My
record.
name is Joe Gagliardi. The address is 50 Berkeley Road. So, is this the only opportunity the public will have to comment on this project at this point? This is it?
That was the thought. So unless there's yes, that's how we normally have hearings as public comment goes and unless there's a reason to keep it open.
Well, you do understand, you didn't give us the information we need to even respond in an adequate way, right? It's already been commented on. I didn't hear your comments as regards to that, but we didn't have any information. This project was going to be reheard and rescinded as an opportunity. All we knew was there was a proposal on the table for some modification.
Well, to be fair, what was said was there's a proposed settlement of litigation. Consider stipulating to approve the zoning compliance application for a 40-unit residential development pursuant to section 830G of the Connecticut General Statutes, which is what the initial application was.
Not to recall what the document I got, it talked about it, looking to about an opportunity to see alternate project developments, ideas about what this project could be.
The
So
public,
nonetheless, I don't know if how to put it back on the table, but the fact that this is our last shot is.
let me ask you this. Let me ask the commission. I know it's public comment. If the public would wish another time to have a public comment on this, commission sees fit, fine. I would not like to have, what I would not want to do is have public comment now and public comment later. If you want, if the commission and the public, I can just, it's a little unorthodox, but fine. If there's the thought from the public that additional time is requested, we can do this in 2 weeks or 4 weeks or whatever the next date is available to us. 2 weeks. And if that's the consensus of the public here on Berkeley Road, so be it. But I don't want to do it now and then, so to speak. I don't want to split it up and have double the time, so to speak. So if that's the sentiment from the public, this is somewhat, this is unusual application for us in general anyways. Let me know now.
May I,
Take a
may
photo.
I ask a question?
No, I can't tell who's here for the public on Berkeley Road. Is this mostly everybody? Yeah, okay, that's a fair set. That was my guess. Does the public wish additional time?
I don't agree with the option of only single. I don't think the option is viable.
I think we should
be able to
let,
speak at both meetings.
right, that's what we're voting on.
Well, I mean,
More time.
Back in 2 weeks.
time
Had it
is
till Saturday that this was a meeting here.
for people that wish to be heard tonight.
Jeez, what do you say?
Like, can we make, what I don't want is to have people essentially I don't want to double the time, so to speak.
Sure.
If there's people that want to be wished heard tonight, fine, I'll keep public comment open for people who want to speak the next time. Is that fair?
Well, we pay the taxes for this time over here.
I don't think, my understanding that if I speak tonight, I'm not allowed to speak at the next meeting, so.
I try to avoid it, is my point.
I understand, but more information is going to come forward, which we may want to discuss
Certainly
further.
is.
In other words,
That's why,
in that 2 week time frame, we're going to learn more. We're going to have more to present.
well, then,
That's why
maybe
we
it should
should
be- why don't we have public comment next time then?
Do we receive emails? Is that
You can always receive emails, certainly
part of the record?
Yeah.
That one a little while.
email will be part of the record.
Commissioner Noonan, could you just explain the process to the public?
Well, I'm trying,
To clarify it, because it's probably not something they've experienced.
well, I mean, as I said, this is somewhat new even for us as far as litigation, settlements. And like any other public hearing, the public has a right to comment. Now, it's not my intention to cause confusion in the beginning, but I guess I did inadvertently by giving what the options were and giving the settlement history, because in my view, that's what happened, and I wanted the public to know. I thought the item was properly agended, but reasonable people disagree. And I can see that people disagree with me, which is fine. In any other public comment portion hearing, I keep public comment open because we run out of time or new information is to be given. That's fine. So if the public would like extra time, and I kind of got the sense the majority would like extra time, and people are expecting to get more information, though, I mean, I think we've kind of said everything as far as new information that's going to be given to the public. If you want time to digest it, review the tape, we will keep public comment open, and we'll do it next time.
Question. We have not seen the plans for the reduction of the floor as an example.
Either way,
Okay, so we don't know if line of sight has been adjusted. We don't know what slope angle is. We don't know where car parking is going to
we're
be.
halfway, I'm sorry, have we?
No, the presumption is it's the exact same site plan, 2 spaces removed for the laundry room addition and with the story removed. It's the same footprint of the building.
I thought there was
same-
an ADA sidewalk going to be, a compliant, ADA compliant sidewalk going to be installed.
I thought that as well. but
Site plan is not proposed to change.
So
whatever
the
site plan is.
ADA requires a 6-foot curb next to it, which is not available on that site. So what I don't know is, where's the fill going to come from? How are they going to modify that slope? We're talking about a level slope exiting the property. I don't know how you achieve that without being halfway into the street. So if you do change the slope, the cars parked on either side are within 10 feet of the front of the property. How do you get in there? You're going to be on a slope like this. There's no way. So my question is, how many parking spots are being lost because of a modified slope as it relates to the ADA compliant sidewalk? Where are the drawings? And
Site plan.
how do we know as the public? I mean, well,
I understand.
public is, we're the ones left to litigate this, which is really unfortunate. We thought we litigated this and it was adjudicated when we came here last time. I don't know how it's possible that you have the right to take an adjudicated case and decide arbitrarily based on a lawyer's opinion that you can't win. We came forward as the public. We can convince the majority of this board that there were safety issues. And you have abandoned that based on the arbitrary information of a lawyer. So for the lawyer's point of view, what case law have you cited? Do you
I think
have?
that's not really what he said.
What I have to look at, the information I just heard is the lawyer said we can't win.
That's not what he said, but
Who
that's okay.
said that then?
One of our people here interpreted it that way. I didn't. Some people did. I don't.
So we can't. So there's a possibility of winning.
Let's not go too
Okay,
crazy.
great.
There's always a possibility.
Great.
So, listen,
So
public has asked for additional time. Other people on the commission has said as much. I don't mind granting that additional time. So you can review what the initial site plan, which is attached to the agenda, right? A link to all the plans for the initial application were linked up. You can review them. You can review the tape, what we said, what the options are.
are you going to require the developer to submit the new plans based on this request for reduced size? I mean, how else do you make a decision if we can't see the plans for the modification?
Sir, I mean, as we said, the proposal was the same site plan with 1 less story and then 2 parking spaces, I believe, removed. So we have been going off of that.
So you're going to ask the developer to show you the new plans. Okay. Doesn't that seem suspect?
I mean, how do you make a decision without seeing the plans? I don't get.
That's the presentation of at least the offer at this point, at least to settle, plus the other options that are, the two other options that are available to us.
Okay, so question, when you assume that this is going to be very, so this is what my assumption is, that this is going to be very difficult to win in court. Is that a correct assumption? I think what you said that, right?
Yes, that's my belief.
All right, so what
Now,
information?
yeah, let's, sorry. If additional comment, if the rest of the public would like a comment to be done at a different time. I don't want to have public comment open both times. If you want to have public comment,
All I asked,
additional time for next time, you've asked for more
all I
time.
asked was, how did you conclude that this is going to be too difficult to win?
I said as much in my presentation.
Did you identify case law? Did you define any other 830G projects in town? Did you compare the issues associated with Berkeley against those other locations? Did you do that? Because I don't know
I said
how
as
you,
much, I will say what I need to last time.
so this is just arbitrary. I
It's not arbitrary.
will continue. On March 25th, I submitted to the TPZ Commission via emails.
We having,
Wait, point of order, are we doing comment tonight?
yeah, that's my.
Well, that's what I was trying to get a sense of. Most of the people I asked if they want public comment to be done in addition, another time, most people raised their hands.
In addition to tonight. So
don't-
public comments tonight, public comments after we get a chance to review, which we haven't, all these
I would like
modifications.
it, no, if you, this, even a bunch of people have said they want to speak tonight and then have more information and speak on that later. I think the most efficient use of everyone's time is to take the time to get the information, update your presentations and do it the next time.
So we're closing the public hearing?
That was what the request was, with more additional time.
No, it was
Not-
tonight, and I wasn't suggesting, because I made the comment, I wasn't suggesting that we close the public hearing tonight. I was suggesting that we should have another opportunity after tonight to review what we hadn't had access to.
Why is it that we can't have it all done at once?
I don't know. I'm ready to go. So why
It
not?
sounds like everybody else wasn't though
So
initially.
can we do another vote of the public? Who's ready to present tonight their issues? 3, 4, 5, 6, 7, 8 people?
People online?
I saw 4. Can you raise your hands again, please? 1, 2, 3. Okay, I just want to get clarity on who wants to go next week and who wants to go next week. So,
Mine, I would like to speak tonight.
no, I know, but I counted 4. So raise your hand again.
Yeah, everyone wants to go. I mean,
Raise your hand tonight, 4. Now, who wants to go next week? Please raise your hand. All right, so 1, 2, 3.
no, don't, because the people are gonna come up. I'm not gonna stop them for speaking.
All right.
Commissioner Levy?
Make a motion to adjourn this matter for 2 weeks. 2 weeks, the hearing open.
Or Harrison?
I'd like to hear from the people tonight. They've been here, they've been very patient, and if some of them are ready, I'd like to hear from them tonight.
Okay.
Go ahead.
I'm ready. All right. On March 25th, I submitted to the TPC Commission via email 2 videos, a photo, and 2 charts for your review. We also copied Jim Wendt and Emmeline Harrigan. Did you all have an opportunity to review this material?
No, we're not gonna answer questions the whole time. We were trying to get back and forth.
Well, it's important to me to know whether or not you took a look at the materials I sent you.
Yes, and if people haven't, they will. Please continue.
Okay. So, just for the record, I submitted a video, 2 videos. One showing the line of sight issue associated with pulling the car out of this property's driveway and to where the driver had to be in order to see oncoming traffic. And the video shows that individual to see traffic the car had to be halfway into the road to see anything. The second video was an accident on Berkeley Road where there was congestion at the road by Alton Place. There were a van, there were pickup trucks, there were cars and cars coming down the street. They can't see that a pickup truck is coming because the van is blocking their view. They come into the intersection and they get hit.
because there was another vehicle waiting for this to happen. So I don't know how many accidents, because nobody did a study on that. How many accidents are really truly occurring on the street? Maybe not even reported. So that's 2 videos that I submitted. So, I want to suggest that this Berkeley project suffers from a serious and potentially deadly design flaws. So first, this project will attract occupants based on its desirable location, and at the same time, put those residents on a dangerous street with no sidewalks to access these locations. The walkability scores for Berkeley LLC project score higher than any other approved and constructed site in the history of Section 830 Fairfield. Residents of Berkeley will be able to walk to public transportation, grocery stores, a gym, pharmacy, restaurants, a diner, fast food establishments such as Dunkin' Donuts and Subway. Do pedestrians currently use Berkeley Road to access these services? Last time it was stated by, I think, John Fallon, that nobody uses Berkeley to walk to these stores. Although no study was conducted to determine the actual numbers, we submit to the record a photo, which you have, of 4 grocery carts located at the intersection of Berkeley and Alton. They were obviously used to shop at. Anecdotally, we also spoke with a few pedestrians during a brief time on Sunday, the 24th. One was walking their dog. The other couple were carrying a shopping bag in hand, walking to Stop and Shop. Contrary to the statements by council, residents do walk in this location. What makes Berkeley Road so dangerous for pedestrians? The high density of parked cars on Berkeley, trucks, vans, SUVs, and pickups, the restricted line of sight for vehicles exiting the location, the lack of sidewalks, and the fact, based on my 30 years of residency, Berkeley's a busy road. Is Berkeley a busy road? The town and its attorneys have relied on one traffic study to determine the number of vehicles using Berkeley. The results of that traffic study indicated to them that Berkeley was safe for both vehicles and pedestrians. We have submitted evidence derived from the Fairfield Police Department study of vehicular accidents to suggest that this traffic study cannot be relied upon. The Fairfield Police Department statistics show that in the code year of 2020 to 2020, which is when this traffic study was done, there were 51% fewer vehicular accidents. Over the prior 10 years, there was a 1 to 2% variance year to year in the number of accidents. COVID shut down our town and dramatically reduced the number of vehicles on our streets. The traffic study being used to determine the safety of Berkeley Road used traffic numbers during a time when our streets were virtually empty. It's not a big leap to assume that half of the volume of cars were on the road when the study was conducted. Since the approval of this project is based upon flawed, erroneous data, and regardless of any modifications submitted by the developer, in my opinion, it must be rejected and adjudicated in court. I'm also of the opinion that the town's refusal to conduct a second traffic study to remedy this known problem should be investigated and the responsible parties held accountable. I would also suggest that when an independent engineer demonstrated discrepancy in findings of line of sight issue in this situation, the town should hire a third party to remedy the discrepancy, not go back to the original engineer and who relied on his original data, and completely ignoring the new engineer's perspective, which showed a significant line sight problem. Finally, when there is any possible issue with a vehicular or pedestrian safety for proposed development, that all stakeholders, such as the town police, fire, TPZ members, and town engineers, visit the site in person. This was done on a very limited basis for Berkeley LC project. Thank you.
Thank you. Can I just ask a question?
Yeah.
Is that the same letter that we got it by email exactly, or is that a little different?
Well, that is a little different. And the email actually shows you the charts from the department, from the police department, showing that the dramatically reduced vehicular incidences in 2020.
I saw that. Is it too much to ask to send the?
I will send this tonight. Same address.
Thank you. Thank you.
Steve Reisinger. I live at 258 Berkeley Road. I just wanted to state for the record, this week I was involved in an accident on Berkeley Road caused by one lane. Trying to let a truck go by. Another car assumed that I was stopped for some unknown reason, tried to pass. As I proceeded, we collided. There's just not enough room on that road. I have 3 vehicles. Where am I going to park my cars? Can I put another driveway in? I don't know if that's possible. Where am I going to park? Start parking on another street? That's a concern. On average at 270 Berkeley Road, the police are there 3 to 4 times out of the week with 3 to 4 cars, a fire truck, an ambulance. Shuts the whole street down, but we're going to add more. That's all I have to say. Thank you. Have a good night.
My name is Tim Brzeski. I live at 315 Berkeley Road. This gentleman here brought up a lot of good points that I was actually going to speak on myself, as far as the traffic study that was done right at the end of the pandemic when businesses and people weren't really
Speak a little louder, sorry.
getting back to work. Also,
Hold that a little closer to you, sir. Yes, sir.
I'd like a little information as far as, as far as the soil test that was done at the time during the conservation. I'd like to do my own private soil test and just looking for a little information as far as how that could be done. Because I believe that was done incorrectly, was done during a major drought. And that could have a lot of contradiction on the whole development and everything else. These are just points as far as the conservation goes. The traffic study, like the gentleman brought up, I think is very important. I think that should be redone. As long as, as well as the other businesses around the area that, there was no study on that as well. Another gentleman, my neighbor Jim, had presented to the last zoning date that the width of the road was incorrect. So there's some studies that were presented to the town of Fairfield as far as the permit and everything goes that we believe that are incorrect, and I believe that should be also overseen as well. I have no problem getting these own soil tests done and traffic study done on my own if the developer and the town are willing to pay for it. But that's pretty much where I'm at right now, and I'm kind of investigating that a little bit. I'm also going to make a call to the state fire marshal to oversee the existing studies of the width of the street, because that they had already signed off on this, the safety, public safety. Okay. My daughter walks to school every morning to McKinley School. There's no bus transportation because we live so close. Okay. There's a lot of stuff here that I think that we all brought up good points about, and that should be, clearly, overseen and addressed, for our own, concern and peace of mind. I don't understand how that's not possible, but I'm going to do everything in my power to continue this, and then if this does get passed, I have I'll appeal we'll appeal that as well. The zoning. Thank you very much for your time.
Thank you.
Yep.
Come on up, sir.
My name's John Petrola, 181 Berkeley Road. I'd like to first thank the commission for inviting us to participate tonight in this process. Understanding and respecting the fact that you have been working in executive session. There's been little insight available to the public regarding any proposed settlement until this meeting this evening. I respectfully submit that if this were to advance any further regarding a settlement of any form, a more formally documented presentation of the proposed settlement should be made available to the public. so that the public would be afforded the time to have the information more thoroughly reviewed, consulted upon, and formulate an informed response. As you have seen in your previous meetings and in our submissions that led to the original denial, the Berkeley Road neighborhood stands united in opposition to this development due to the quantifiable harm that it imposes on our neighborhood. I also want to thank the town attorneys for their support. I visited the judicial website and read their brief submitted to the court regarding the appeal. It is encouraging to see documented in that brief the legal precedent in multiple cases where the court denied the appeal and upheld the original decision of the commission. We are confident that the same justice will prevail in our case. I stand ready to be called as a witness in that case to present and attest to the court all the documentation, photos, and testimony that I have presented to you supporting your original decision. We're certainly not going to relitigate the entire proposal here tonight, but I would like to restate just a few of the deficiencies in the applicant's original proposal that seem unlikely to be remedied by any settlement. Deficiency number one, the applicant's project remains locked in a separate litigation for failures of due process during the Inland Wetlands Conservation Commission review. Although that separate litigation is filed in the name of one person, the neighbors collectively support that process. This separate litigation regarding the Wetlands Commission cannot be remedied by a settlement or any other action by the Plan and Zoning Commission. Deficiency number two, the traffic study presented by the applicant was conducted during the height of the pandemic. It presented erroneous traffic volume data relative to post-pandemic living. There was actual traffic data routinely accrued by the state of Connecticut DOT, which clearly demonstrates the large disparity of traffic volume between the pandemic timeline and post-pandemic. This large disparity holds true for Berkeley Road as well. Updated traffic volume data that was requested in previous P&Z meetings was not produced. Deficiency number three, line of sight and stopping distance data from the applicant's original submission was challenged and found inaccurate by an independent engineer. Clearly, the line of sight data fails when real world situation of parked cars on the street is considered in the calculation. When the town engineering manager, William Hurley, subsequently revisited the ISD calculation, he responded to Mr. Wendt in a May 19th, 2023 email. He specifically stated, and I quote, "I would recommend additional safety measures such as no parking along the frontage of the site and confirming low slope platform less than 3% for the first 20 feet of access to ensure actual field site distance is met," end quote. Some key points of Mr. Hurley's statement are this. The engineering manager of the town is identifying these as safety measures. This speaks to the public safety impediment of an 830G implementation. B, Mr. Hurley says these are required to ensure that actual field site distance is met, meaning that it must be considered in the context of the real world situation on Berkeley Road, not on a paper drawing, in the actual field. He is talking about no parking allowed along the frontage of the site to make it safe. In other words, parked cars in the line of sight, it fails. Realistically, we all know that without actual police enforcement, there will be parking on the street in front of this site. So the actual line of sight will be obscured in the real world. I need to be very clear on my next statement. I am not stating that I am in favor of improving a settlement that has been unseen until tonight by the public without due time to review and consult as previously stated. However, if there were to advance someday to some reasonable form of an agreed upon site configuration, I implore this commission to make the engineering manager's recommendation for no street parking a formality. The commission should stipulate that police enforceable no parking signs are a requirement for approval. Not just a recommendation, a requirement. Let me rephrase that. A required condition for any approval would be that the Fairfield Police Department installs no parking signs across the frontage of the site as per the town engineer's safety statement. The applicant points to a May 8th, 2023 email from the chief of police stating an approval of the plan. That email response was dated prior to subsequent P&Z meetings and submission of testimony and evidence of the errors and deficiencies in the original traffic plan submitted by the applicant and conflicting line sight studies. That information was not available to the chief of police at the time of his email. This line of sight is serious as a serious consequence. This does not only involve the intersecting automobile traffic on Berkeley Road, which will be hazardous. It will impact the young children bicycling past the proposed complex driveway, as you have heard in previous testimony. The children's safety depends on visibility of them by the drivers exiting the site. To achieve that visibility, there can be no parked cars in the line of sight. We have a Fairfield Police Commission that is responsible for traffic safety. One of their roles is the review and application of pertinent traffic safety signage and its enforcement. By this commission documenting this requirement, you will be mandating input from the commission that is actually responsible for this subject matter. Police Commission will clearly see the conflicting needs of this case. They will see established residents and their need to have on-street parking due to their densely populated housing and limited driveways versus the line of sight requirement, the hazardous exit driveway of a proposed complex. I am confident that the Police Commission will conclude appropriately that they cannot take away the on-street parking and therefore reject the applicant's proposal in its current design, further confirming the Planning and Zoning Commission's original denial of the applicant's proposal. To the applicant, I repeat my statement from a previous P&Z Commission meeting. I am a believer that one has an obligation to not only identify the flaws in a situation, but also to be part of the solution. I would suggest that it could be financially attractive to the applicant to build a series of duplex homes on these sites, or I would suggest that the applicant refer to the concept of the Pine Tree apartment complex on nearby 15 Pine Tree Lane as a model of what could be minimize the health and safety concerns and be welcome to the neighborhood. In closing, I repeat that I am not in favor of a settlement. I believe the commission's original denial of this application was correct. I believe that our documentation and evidence clearly supports a denial of the appeal. I trust the judgment of the court to reach that same conclusion, and I stand willing to be called to testify to that end. With that, I submit a signed copy of this statement to the commission for inclusion in the record and thereby invite the town's attorneys to use it in full or in part for presentation in court as they see fit. Thank you.
Thank you, sir. Mayor Harrison.
Mr. Petrola, thank you for being here. Will you be emailing that to Mr. White?
I was going to handle a copy, but I can certainly email.
I'll take care of that. Thank you.
Anyone else wish to be heard tonight, knowing that you'll have
Good evening. What do I just?
It's fine right there. Thank you.
I'm gonna be short. Karen Baturla, 181 Berkeley Road. I concur with everything my husband said. I'm gonna go back a little bit on an email from Mr. Bishop. And I would just like to read a few exchanges that I had with him. As part of this investigation, I recommend that the applicant retain a professional to utilize ground penetrating radar, GPR, to determine the location, extent, and depth of the presumed channelized watercourse. Given my 18 years of professional experience, environmental investigation, remediation, I have conducted hundreds of subsurface explorations using a GPR vendor to locate utilities, underground tanks, piping, historically filling, excavation, and other surface structures. I trust local vendors such as GPRS or Underground Surveying LLC have the skills and tools to successfully locate and explore a structure similar to what I observed in the field and generate valuable information to be included in the review of the sex application as it relates to this report watercourse. I confirmed over the phone with one of the vendors above that a typical day rate for the professional services is $1,600. I responded, "Hi, Tim. I am Karen Baturla. I live at 181 Berkeley Road. We spoke the next day after the meeting. Just curious, Agnes Stopa-Grzeski is observing right now men on 301 property digging a hole. According to your report, your recommendation was an underground survey company with underground penetrating equipment. What Agnes is observing is unmarked truck, some men with shovels, a pick and a rod. And is this the procedure that is supposed to happen?" My response was, I am unaware of the activity and will look into it. Nothing was permitted, especially any ground disturbance, excavation, while the permit application remains unapproved. My recommendation involved ground penetrating radar, which is an expensive piece of equipment that looks like a lawnmower with 3 wheels. So my question on this is, how can we be discussing a settlement when it's still in the courts for wetlands? And also, since our last meeting, the parking density on the street has doubled. I don't know where the cars come from. We have a lot of renters with no places to park, not enough driveways, but the street, we live on the hill, it's horrendous. And the traffic, double parking on both sides goes from the top of the hill down. It's awful. And just a piece of history on Berkeley Road, my neighbor that lives across the street from me, she's 90. She's here. And her family was one of the first families to settle on Berkeley Road. Her relatives were one of the first houses on Berkeley Road. And she remembers, well, actually, Berkeley Road wasn't supposed to be where Berkeley Road is. Berkeley Road was supposed to be where our backyards are. But because of the wetlands, Berkeley Road, the road, was put behind our houses. It developed behind. There's a brook behind my house that is fully running, and it runs the whole course. And the properties down on 301, 277, they, according to my neighbor, as she remembers as a child, had a running stream through the middle of their backyards. So there is a wetland property problem, and I don't understand how we can move forward to any kind of settlement when it's still in litigation with wetlands. And there is an existing problem, bless you. And thank you for your sympathy on our problem. I mean, it's very upsetting, and I know you guys must put a lot of work in, and thank you.
Thank you.
I had a question because Mrs. Petrelli, you were referencing the wetlands case, correct?
Mhm.
Okay, I mean, just so you know, wetlands is not governed by 830G, what we are. So it's been, I mean, I don't know.
Yeah, but we can,
Are those emails submitted in the record already, or are you going
I don't think so.
for them?
Sure.
Thank you.
any other member of the public wish to be heard tonight, knowing again that we're keeping it open till next, in maybe not 2 weeks exactly, but our next hearing, next meeting. Anybody, Miss Harrigan, remotely or by phone that you know of?
Yeah.
Is anybody joining remotely or by phone that wishes to be heard tonight on this application, knowing that keeping the public comment open until next meeting? If you're joining by phone, please press *6.
And Mr. Chairman, I do want to thank you for keeping it open. I'm sure it's appreciated by the neighbors and the commission. So thank you.
Yes, thank you.
Not, yes. Mr. Went, the materials online are where?
They're linked on the agenda.
Linked on the agenda. So if you can, on our town website, the agenda is posted under the plan and zoning. Apologies, I don't know exactly where, we always get them emailed to us, but they are there. Materials are linked on that. So if you click on tonight's agenda and even next week's or next meeting's agenda, there'll be a link underneath the
If anybody
item.
has difficulty, they could call or email our office and we'll send them the link.
Having heard that, I'm going to not close, adjourn, hearing for tonight, to our next meeting. Not closed. Public comment is not closed.
Thank you.
Thank you.
Thank you.
It looks like people may be leaving. I'll give them a quick minute so we move on. Attorney Baldwin, thank you.
Charlie, the letters.
I know you're doing, Ms. Harrigan. No worries. Wherever you feel comfortable, there, here, wherever. Why don't you come up? I mean, because that's what we normally do. Okay. Perfect. There is a, this, which is. Double check. I'm not sure the exact answer. Yeah, we can ask. As people are filing out, our next item is P O C D discussion, but we're gonna put that towards the end so we can get to some other business. See, we'll be doing that in public no less, but that's not gonna be hearing for that, so we'll speak to other items.
Can I make a left to go to new applications?
If we need to, Mr. When do we need to, or can I just as chair?
I think that's your call, is if you're going to just take.
Mind if I just-
I don't think you need a formal vote.
No. I'm gonna move to item 2A. New applications recommended public hearing, 86 French Street, special permit application for a rooftop in the Beach District Zone.
There's a word missing there. That should be a rooftop deck.
Yeah, I guess that would make sense.
Should ever.
Yeah.
Yeah. The beach district regulations require a special exception application for rooftop decks. So it's a bit of a quirky piece of the regulations, but nonetheless, they made the application, does require a public hearing.
Thank you. Have a motion, please. Commissioner Corsillo,
Move to public hearing.
thank you. Second. Commissioner Harrison seconds. Any comments?
Required.
Commissioner Ford, are you still with us? Commissioner Seaver, why don't you step in? It's a motion. It's a pretty uncontroverted one. We put this to a vote. All those in favor, please say aye or raise your hand. See 7 hands, passes unanimously. Next item, old business, Catamount Road, petition of residents for scenic road status pursuant to the scenic road ordinance. Ms. Harrigan.
Okay, so for Catamount Road, chapter 88 of the town code allows for designation of a scenic road with the signed statement of approval by owners of a majority of lot frontage on the requested portion of the roadway. The scenic road requirements are also referenced in section 7-149A of the Connecticut General Statutes. The applicant, Mr. Kazukian, has been able to obtain owner signatures for 56% of the frontage on the requested roadway. The designation is requested as Catamount Road meets the following recommended criteria. Number 1, it is bordered by mature trees or stone walls. Number 2, the traveled portion is not more than 20 feet in width. Number 3, it offers scenic views. Number 4, it blends naturally into the surrounding terrain. And number 5, it travels over rivers or streams. Per town code, no town road or highway may be designated as a scenic road if it contains any condition that poses a safety risk to travelers. 2, it contains a condition that limits adequate public safety provision by emergency service personnel, or 3, it contains any condition that limits the police officers to carry out the duties of the town. Town departments have reviewed the application and do not find conflicts with the above. In addition, the engineering department has confirmed that there are no expansion plans for Catamount Road that would conflict with its designation and its continued use in its present configuration. Scenic road designation does not preclude regular roadway maintenance such as paving and repair. However, if they did want to do a very large improvement project that would change the nature of that roadway, expand the width, that would be something that the engineering department would have to bring before this board if that designation is provided. That's all I have.
Thank you, Ms. Harrigan. Commissioner Ford, are you with us? And are you up to speed? No, I don't either, which is fine. Commissioner Siebert, you're still in on this. You're in on this, vote. May I have a motion on the item? Commissioner Levy,
Yeah, I'd move to approve the designation.
Commissioner, is there a second? Let me start that. Commissioner Braun, seconds, yeah. Commissioner Levy,
Yeah, I've ridden my bike on this road a number of times. It's certainly scenic, it's certainly hilly, and it meets the criteria to be designated as a scenic road. And apparently there's no safety conditions that militate against that, so I'd recommend it.
Commissioner Braun,
Would concur with everything Commissioner Levy said. It satisfies both the statutory and regulation requirements. I think it meets all the criteria. It only, I think, had to be one of them, right? And they also got the buy-in from the people that live on the road, as well as the public safety departments of our town. So would support it.
Commissioner Harrison,
Yeah, I would say that this is a true asset to our community, and scenic roads are certainly a finite item, so happy to support this, this item.
comments, thoughts? Commissioner Randolph,
I'm glad people of this town have taken the time to preserve the natural beauty, and I agree that this is a scenic road like Commissioner Levy. I've ridden my bicycle on this many times. It's very hilly, but it's a beautiful road and worthy of preservation.
yeah, no opposition that we heard. buy-in from neighbors and from our town agencies as far as safety. First time I ever really had to deal with scenic road ordinance. So I don't think we're gonna have an issue with floodgates opening. Maybe we will, but we'll deal with it if that were the case, but seems like a worthy of further comments, or can we put this to a vote? All those in favor, please say aye or raise your hands. See 7 hands, passes unanimously. Next item is 60 Katona Drive, special permit application of Catfield LLC pertaining to conversion of an existing office building to residential use in the design commercial district. Sarah.
60 Katona Drive. The parcel is approximately 0.87 acres in size and is located south of Black Rock Turnpike on the east side of Katona Drive, just south of a medical office building and the McDonald's on Black Rock Turnpike. The building was formerly used for an office building and is requesting a special permit to allow for 100% conversion to a residential building with 18 units that consist of 4 2-bedrooms, 12 1-bedrooms, and 2 studio units. Per Fairfield's inclusionary requirements, 10% of the units, which represents 2 units, will be provided as deed restricted and affordable to households that do not exceed 80% of the area median income. The applicant has provided an affordability plan that identifies where these units are proposed and as mandated that they will represent an equal proportionality of units, 1 2-bedroom and 1 1-bedroom provided and well distributed in the building. The applicant previously received variances from the Zoning Board of Appeals on August 2nd, 2023, to allow for the ground floor to be residential and 100% of the building to be residential in a commercial zone, as well as to allow the existing building to continue to have a 24.99-foot side yard setback adjacent to a residential zone where 30 feet would have been required. The site is served by 2 driveways and 44 parking spaces, where 3 spaces per unit or 54 spaces would be required. However, the applicant requests a parking reduction per section 28.6.1 for the.
Sorry, I just got a text, Commissioner Ford signed off, so.
Okay.
Sorry about that.
That's okay. For the reduced parking, which the board can reduce to 50% of the requirement or 27 spaces. The traffic report indicates that the proposed residential use generates less traffic than the prior office use, and that both driveways provide adequate visibility for safe maneuverability. The northerly driveway is for exiting only. The site contains no inland wetlands. There is a reduction to the on-site impervious surface with the addition of tree wells that provide required shade trees in the parking area and a larger landscaped area in the front. However, as the building is being adaptively reused, no new on-site detention is required per engineering comments. Code comments have been addressed with some requirements that will be met through building permit issuance. Considerations for the special permit are found in section 25.7.7. Is the development shown on the site in architectural plans of such character as to harmonize with the neighborhood, to accomplish a transition in character between areas of unlike character, to protect property values in the neighborhood, to preserve and enhance the appearance and beauty of the community, and to avoid undue traffic congestion. And that's all I have.
Thank you, Ms. Harrigan. May I have a motion on the item? Commissioner Harrison,
I'd like to make a motion to approve.
second. Commissioner Braun. Commissioner Harrison.
Yeah, I think this meets special permit requirements. I think it's going to be a big win to this area of town. Especially that building. It's been tired looking for many years. I think I said to the last time that was my pediatrician's office a million years ago, and it was tired then. And I think this is a great use of space and glad to have the additional affordable units. So looking forward to it. Thank you.
Can I, Mr. Chairman, to clarify that the motion, does that motion include the approval of the applicant's request to reduce the parking pursuant to their?
Yes.
Yes, sorry.
Sorry. Yeah, I'm great with that.
Commissioner Braun, is that the second? Is that good?
Yeah, I second it. And
Okay. Anything further, Commissioner Harrison?
No, nothing further.
Commissioner Braun?
I agree. It It's certainly by replacing the sort of ugly older building with an attractive residential building, it does add to the charm and beauty of the area. It also helps transition between like and unlike areas. It definitely preserves property values. It helps with the traffic situation. It's less traffic being generated. It also, I like the fact that there's enough parking to have the people park on site for this development. So I think it satisfies all that. I'm happy that it reduces the impervious surface and that also it provided good screening with trees to the neighborhood behind it.
Priscilla?
Very much support this application. I think it's a tremendous improvement over what's there now. I actually would have preferred to see further reduction in parking. I think I was a bit more in favor of that than most of the commission. I do wonder, Commissioners Harrison and Braun, how they feel about reducing it by a modest 2 spaces with those spaces dedicated to additional green space, shade trees, whatever, to be designed by the landscape architect as a modification.
So Mr. Went or Ms. Harrigan, sorry, why don't we just quickly, for the record, because we had room in that respect. Can you just quickly say what the parking would normally have to be and what we're allowed to reduce it by total and then where they are currently?
So the current requirement is 3 spaces per unit, which would be 54 spaces required. The applicant is proposing 44 parking spaces, and you are allowed to reduce the overall parking requirement by 50%, which would reduce it down to 27 spaces.
I'm not suggesting we do that. I'm just, because I've forgotten about that little variable. And how many units were there?
18.
There are 18 units.
And for what it's worth,
Thank you.
I think when I floated that at the last meeting, I believe Attorney Fallon said, he's on the line, so he could probably speak to this, that he'd be willing to agree to some further reduction.
They would go down to 42.
42, I believe, it's at 44 right now, yeah,
As
42.
long, I'm amenable to that, as long as the condition is with native plantings, that would have to be part of the condition. I think that's fine.
They were.
Well, we're gonna make it part.
I would make that part, yeah.
So Commissioner Harrison so amends the motion
22 bedrooms.
22 bedrooms.
to move parking from 44 to 42 with the 2 reductions to be done by native plantings.
Preferably trees.
We'll say preferably trees, but the condition is for native plantings, recommendation is trees. Commissioner Braun, do you so agree?
Given that there are 22 bedrooms, I would go along with that.
So move, okay, so right now the motion is to approve with a reduction down to 42 spaces with the 2 spaces that we have further reduced by be dedicated to native plantings, preferably trees. Again, the preferably trees part is a recommendation. Everything else before that is a condition of.
Yeah. And I would just add, I'm agreeable to this because I actually used to live on condos right there, Melody Lane condominiums, which are right there. And that street right there is pretty wide and there's ample room for parking. So I think, I don't think there'll be any safety issues.
Commissioner Garcella.
I just want to thank you to Commissioners Harrison and Braun for entertaining the suggestion.
Couldn't hear that, I'm sorry.
I just said thank you for entertaining the suggestion.
Thank you.
Thank you for suggesting it.
Yeah, I know Commissioner Pakowski, the alternate, she was here, so she must have been not a big deal that suggested even going lower than that, but I think that's a fair compromise considering it's 18 units. It's gonna be more than 2 per unit. You want to, I think, having people parking on street, I think is a last resort if you can avoid it, but.
It is very wide and there is a lot of
Yeah, I
parking
know.
there anyway on the street. I don't think it would be a big issue.
No. Any further comments? Commissioner Levy?
I'll just concur with Commissioner Harrison, 42 years ago, our pediatrician was there and the building was tired then. So this will be, this will be a vast improvement, and, you know, it's largely a residential area between Judd Street and that area there. So I'm sure I mean, the developer should be commended for coming up with a very attractive development that will improve the general neighborhood.
Got nothing further to add. It's a great project. Meets our qualifications. Going down to 42 is fine. Anything further? All right, let's put this to a vote. All those in favor, please say aye or raise your hand. 7 hands, passes unanimously. We'll circle back to the POCD discussion. We don't have, we'll stay as long as we want, but so don't go crazy. But we do need to get this restarted, considering that and get this restarted. Ms. Harrigan.
So that I think to echo your comments, that's exactly why we're kind of just redistributing this to you, just to kind of get the re-review jump started. Really, you know, in providing the update to the POCD, we incorporated all the comments that were discussed. And reordered the document specifically to kind of address, I think, what folks' comments were in terms of what they felt the more significant changes were. And so you'll see that the memo really just kind of tracks those changes, but from a holistic perspective, we heard you. We provided an executive summary to kind of better position what this document includes, where we've kind of made advances since the last POCD, the progress made, reordered the chapters and the organization of the document, so that you know, the more significant change and discussion is leads first, and then we can kind of address some of the other chapters at the end. We did actually make some incorporations based on comments made by the DPW. We also wanted to, you know, we heard that some things needed to be clarified and defined within the document, so we've tried to do that. This is still very much a draft, so, you know, I would say that, you know, there's obviously still room for revision and editing as you guys discuss this as a commission together. We still also have a community facilities map that's pending as well. But we did try to include more information about the school and educational facilities. And we have actually even after we sent this memo and the attachments to it, had even a follow-up conversation with our conservation director, who wanted to add a couple more plans that he'd like to work on in the next couple of years within the document as well. So, you know, what we've tried to kind of express to folks is that we're not trying to incorporate everybody's narrative of their plans within our document. We want to kind of be able to capture their primary goals and priorities, so that hopefully if through grant writing, you know, the POCD is, you know, the town's primary planning document, that it hopefully unlocks funding to do additional studies and projects in the future. We did also, this was recommended in a couple of different places by a couple of folks, and you'll see an Appendix A that provides the neighborhood planning areas that are summarized from the 2000 plan, and also a placeholder for kind of an action table in the back of the plan that will hopefully kind of summarize, as is done in some other documents that we do, such as the hazard mitigation plan, more of an action tracking table, so that we can really kind of take out those priorities and goals and kind of put those as action items in the back of the document. That's just our really quick overview. Commissioner Randolph was new while we were working on the draft, so I did attach his comments for the POCD, which I'm sure he would love to discuss with you guys as well in terms of some of his ideas. So, you know, that's kind of just the overview just to get us restarted.
No, and that's kind of a status of where we are. I don't think it's not as if any previous suggestions that have not been made in can't be reasserted. We're not like just saying, okay, everything that we talked about previously cannot be talked about or amended or discussed or anything like that at this point. But we did what we did a lot of I think a lot of involvement last year. We have some made edits and now we need to get restarted again to it. So that's kind of where we are, and nothing is off the table, so to speak, for any edits that we made going forward. I mean, certainly we can talk as a commission in our planning capacity. I do believe, considering where we are and how long it's been, we should be thinking about scheduling public hearing in a month and a half, or whatever it is. And that doesn't mean we can't. I don't expect one public hearing. I don't expect it to be like a regular application where we present the POCD, public comments, only 2 people show up for the public and we close the public comment. I don't expect that to happen. I don't think that's fair, really. It's not, considering this is as town-wide as it is. I expect having a few public comment portions and then keeping it open as need be, and then we can have special meetings in between or after, or in between makes sense, so we can keep this process moving. But we can certainly talk about, I'm not sure if anybody's in a position to talk, but I know substantively, I've reviewed Attorney Randolph's comments. We can go through them.
You just gave him a promotion. Gave a promotion.
Social like that. Sorry. Maybe we can certainly go through them. I think any kind of discussion moving forward is a good thing. So I also realize practicality.
Procedural
Commissioner Braun, go ahead.
So 2 procedural questions. Attorney Randolph's comment. I'm looking at the email from
My mistake.
February 16th that had the link to the new draft. Is that were his comments emailed to us separately from that? Because I can't find his comments right now.
So unfortunately, Commissioner Randolph's comments were, they reference, the pagination is a little different because his comments were based upon the prior draft
Oh,
before.
so these are January. Oh, they're based on the prior draft.
Right.
Right.
So what you'll have to look for, unfortunately, is he does actually provide headers for the sections that he's discussing. So you would just have to take them in context to the sections that he's discussing.
I've
These
changed.
comments are not incorporated in this draft yet.
There are a couple that touch on issues that the commission has already discussed collectively that we've added, but that were more. There are other substantive comments that are on his proposal that aren't.
So you want to look at this in conjunction with.
Yeah, so I can resend. I went this afternoon. I'm sorry I didn't do it sooner, but
Kind of like what we did. We all submitted comments and suggested edits. He did that. I mean,
Those were incorporated, but this couldn't be.
well, I mean, I won't say everybody's comments were incorporated. I mean,
I will say this, that firstly, I can send you new reference page numbers to those to correlate to the existing draft, because his comments were based on the previous draft. I think it's fair to say that this current draft is a better document and has benefited from the discussion that we all have had collectively and input that we've received from other agencies. We took that seriously, and I think those suggestions made this a better plan. That's not to say that we're done. So what we're asking is, we're moving this back to the front burner, so to speak. So please re-engage to the extent you have issues that you don't think have been adequately addressed. Please let us know so we can focus our energy on those discussions, rather than if there are things that there's agreement on, we don't need to spend time dealing with that. But as the chair said, I think we would benefit at this point from getting broader public feedback, and then then be in a better position to have further discussion as to which elements of this plan need more discussion.
Just my comment on that. I think that's, so long as we're not limiting it to the one mandatory one, then that's great.
It's entirely up to this commission how to proceed. Right, correct. So as the chair indicated, that's what we'd like to see happen, and it's entirely up to this commission, the timeframe of how to proceed thereafter, after getting some initial input.
The other procedural question is, I've asked this before. I know it's a pain, but it's really hard to work with a PDF document. And I know the first time they wrote this up, I guess the consultant, their program or whatever. Can't they give it to us in Word like the first time? Then we can actually mark up changes and get it to easier.
Well, again, I think rather than marking up the document, if you could do what was done
So many
before,
semantics.
if there's something that you don't think has been addressed, then let us know, and then we can have discussion. Again,
Changes because this
But I think
document,
You have to discuss that as a board. Like, we can't take your red line and then make the change to the document holistically without you as a commission having a discussion together.
I think
So
that will.
that's where it's a little
I think that
challenging.
will come. I think what we need to do is make sure that the essence of the goal of policy statements you agree with, and then the wordsmithing, if you've got some semantic changes to make to the language, that can come at a later time. We're not asking you for those things. We're looking at the bigger picture. Does this capture what we're trying to do? Is in what we try to articulate in the executive summary is we're not looking to change. This is a mature community, as you all know. And what this document does, I think, represents where this board has done previous planning work and recognizes where the opportunities are for new development. Development happens as a series of private investments. What we're trying to do is establish, set some guideposts to help direct that private investment. So if someone's going to make a private investment to do a development, we want to make sure it's focused on within the context, the goals and policies that you set out. So I think the bigger picture of, hey, are we touching the right notes on the bigger picture items, and then we can worry about the grammatical issues down the road.
and one last procedural question. So do the categories follow the state POCD? Because I really don't, it's just, I don't like the wording of how we have to have these categories, a community that is home for all. It just seems very childish or something, or like those paragraph, those chapter headings, do they track the state POCD? And if so, I
No,
guess.
the chapter headings are what came out of, discussions and what the priorities were. If you just want to call that, label that housing instead of a community that's home for all. I mean, again, that's up to the
Stylistic
that's up to
thing.
the,
I'm just wondering if we have to stick with things that the state has in their POCD.
well, the things that the state lays out are the issues that you need to deal with,
Okay.
but the title of the chapter is I think what's more important is what are the the snapshot land use policies that you see important for the next 10 years or so, not necessarily how we're labeled the chapter.
And what, oh, sorry. I'm done for now.
Go ahead, Commissioner Harrison.
Yeah. But thank you for all this. I really appreciate it. I have some 5 or 6 broad statements. Would it be easier to email them to you guys and then the commissions if they see them? I know it's getting late, but I just had some feedback.
Yeah, I mean, again, I'll leave that to you if you want to articulate that now and follow it up with an email. That's fine.
But I do think that some of the, I think that you need to have conversation as a commission together. So I would like to
that's what I was
kind of
asking.
get away from some of the individual emails
Mhm.
because you have to discuss this document together. You have to make decisions together on the document.
Would it be possible to have a meeting dedicated to some,
Yeah,
Sorry.
absolutely.
No, because that's what we want.
That's what we want.
Yeah. We
dedicated
want
to
special, I want to have a special meeting, special meetings,
Working session.
a working session, whatever you want to call it, to discuss this, just so we're dealing with this.
maybe even cover like 2 aspects of it or 2 chapters or
Got
something?
it. Yeah, and I think at some point when we get past the broad general goals
Mhm.
that we're gonna want to discuss chapters individually or pages, whatever. Because I know you guys want to go through details, and I think that's fine when we get to that point. And I think that focusing it on chapters or pages or whatever. Good idea. Doing it, in one having a meeting dedicated to it is the way to go, and not at the end of this meeting where it's 9:00.
Yeah, that was our, we were hoping actually that at the next meeting, the 9th, we might have some time for that, but I guess we're continuing the. So we can,
Because I wasn't sure if we were already filled that next time.
well, we have, actually, right now, we're in a pretty decent application window where we've got some time to dedicate for this
Okay.
discussion. That may not always be the case, and what I need to know, I guess, is how much of that discussion you want to have in advance of hearing more from the public, or do you want to hear from the public and then have that discussion, or have the discussion and then hear from you?
I mean, I think at some point we would do them simultaneously to some extent makes a little sense because we have been involved with this for so long. We may get into the nitpicky on certain things and the public may or may not be in that position, that level, because the public comment generally is kind of high end, 40,000 foot view, and we may be in a lesser degree to that because we've been living with it so long. So I have no problem, for an example, starting to look to target next month, the second meeting in April, start public comments, just start it, not end it, obviously. And then we could also look towards either middle of April, or even in between the April and May 1 meetings to have a special meeting for a working session. And let me go down the line. So Levy down this way.
What dates are we looking at?
Well, I don't know. I'm just getting a suggestion.
Commissioner Architect Randolph's comment or notes. I mean, there's a lot of new good ideas there and stuff that I didn't learn in law school. So I'd like to spend some time just Commissioner Randolph sort of running us through the ideas as far as ADUs and sort of model, model plans for ADUs and so forth, which are sort of new ideas, which are not incorporated. So, I mean, I think that would be, spending some time just going through all this good work would be helpful. So.
We could, yeah, and I think commission members still giving input to staff may make sense, so we can see where there are, like you had some thoughts that you probably want to get addressed as well, and maybe if there's some overlap with Commissioner Randolph, and I don't know that offhand. But we should be making agendas for these special sessions at the very least to discuss certain items. So maybe, we have Commissioner Randolph. I think it may make sense if you have things that you still want, either new things you want to discuss or even things that we haven't been yet incorporated to some extent. I mean, I think maybe giving those to staff may still make sense. So we can see what else is there to make agendas for special. I mean, you guys, staff, do you?
No, I don't disagree. I'm just looking that as luck would have it, there are 5 Tuesdays in April. Our regular meetings are scheduled for the 9th and the 23rd. I know learned this evening, I think that Mr. Randolph is not available on the 9th. We are looking to continue, I guess, the Berkeley discussion on the 9th. We may be able to do some other matters. I don't know. Hard to tell how much more public we're going to hear from Berkeley matter, and then you folks have to discuss that. So perhaps the April 23rd meeting on a regular agenda, we have some time, or we can send out an email to see what we can schedule specific meetings for discussion purposes, potentially on the 16th and or the 30th of April, which are, if you want to stick to a Tuesday format. We're not married to Tuesdays, but
April 6th.
so you don't have to answer that now, but just to consider if we are intending to add some meetings to the calendar for the ability to have those discussions. And then maybe in the early May timeframe, think about an initial public hearing presentation for public feedback, and then go from there.
Harrison?
Yeah, thank you. And I, of course, want to hear what Commissioner Randolph has put together, of course. But we've had such a long hiatus from this. I feel like we didn't get very far when we ended our last discussion in November. I thought we had a really substantive discussion that night and it was really good. I guess I kind of want to go back to where we left off and then start with the new stuff after that. Because I know some of my, I'm speaking just for myself, some of my questions were not addressed during that session, which is fine. There was a bit back. So I'd like to start, where we left off and then continue forward with the new material and
Okay,
ideas.
well, why don't we? I think it behooves everybody to get your thoughts on paper. And if staff is still amenable to the idea of taking it.
Yeah, I think it's
seeing-
beneficial to know where the issues are that we need to still iron out.
Yeah, and then, listen, whether it's done first, second, or third, it needs to be addressed anyways, but your point's taken that maybe going in order is fair. I don't think, it depends on what needs to be said, what needs to be addressed. But that's, as a commission, I would think members, everybody, we can look to get our comments in. Again, this is working stuff. I'm not expecting to be the last and only chance to get comments in. You can get comments in next 2 weeks. Ish.
Yeah, if you think that if you have unresolved questions or you think we've missed the mark somewhere, let us know so we can re-engage on where we should be spending our energy talking about.
If there's a chance you can separate the two out, unresolved versus additional comments, maybe that helps organization to some extent. Iron, obviously.
Starting to talk about what parking, I think it feels like a lifetime ago at this point, but I forgot, I have to look back at the tape.
The post-road district.
Yeah, we're talking about post road.
Yeah.
As a result, when you have the opportunity to go back and look at the red line now, we made some adjustments there. Certainly, in many cases, made the recommendations less declarative and more, consider this as the discussion went on. There wasn't, complete unanimity of opinion on some of the matters, so we left it a little more, we softened up the language, so to speak. So yeah, if you've got issues you think we need to talk out more, that's.
We're going to get to the point where it's going to be, an issue. Some people agree, some people disagree, and majority kind of, should rule, so to speak, so we can move forward. There's going to be compromises, win some, lose some issues, and then it's a matter of, at the end of the day, with the draft we have, having the public comment on it, and then we don't adopt, whatever the case may be. But we are getting to that stage where, at some point, decisions are going to need to start being made, or compromises or whatever.
So we'll start with that working session then, it sounds like.
I think so, and think about whether it's going to be the 16th or the 31st. Is that what you said?
Well, we could consider including both, in to the extent we need to. So, just for planning purposes, pencil them in if we can, and then, the conversation will dictate.
Sorry.
I have plans to be on vacation on that week of April 16th.
Okay, that actually may be as well.
Okay. Well, again, we'll send it out to see what your availability is. To the extent we can carve out some time. There's the ability to use portions of an agenda if we're not doing a public hearing. If you just have some matters of old business to discuss, then we can roll into a discussion. We can deal with that. It's hard to do public hearing in conjunction with.
No, I think that's true. Commissioner Priscilla.
Yeah, my suggestion, I think this is in line with what you were saying, Chair, is that any conversation, any special meetings we have prior to public hearing, which I'm eager to get to, would be best served focusing on things that are not yet in the draft POCD that we want them to prioritized over changes, because I think when we get to public comment, we can still weigh in on changes alongside the public, but the public can't weigh in on something that's not in the document. So I know there are things that probably all of us or most of us have suggested that aren't reflected yet, Commissioner Randolph and his ideas that are subsequent to the draft. So
I
think we can have a discussion about what items we've suggested that should go in prior to, so the public can weigh in.
I think it should be both. Unless somebody disagrees, I think it's got to be kind of both, because we still need to have the discussions at some point, the draft is gonna get amended again.
Yeah.
And we're gonna have to go to public hearing again. And that could happen one or two more times thereafter. I mean, obviously, whatever draft we get to as a quote unquote final draft is gonna need to be to public hearing. Correct? I mean, we disagree with that.
Yeah, I mean, that's gonna,
So
depends on how.
I don't know when that's gonna be, but I mean, I don't think we need to, I think our working sessions can be about what the commission needs, whether it's new or old. We should get public comments, do that simultaneously and jointly, and then that will lead to further amendments, revisions, I suspect. And is that a fair point?
Yeah, yes. And again, you don't have to decide now how you're going to proceed. We need to just start re-engaging in that. And I think that will dictate how we go. But at some point, you're going to want to get some public feedback.
Right.
And then to the extent that changes the draft, remains to be seen. So it sounds like, is that a school vacation week that?
Yes, actually, it is. That's why.
Maybe that's not a bad. The possibility of having some substantive discussion on the 9th, again, I'll consider that. Again, I'm hard to.
I think that might be a little too soon.
Okay.
Unless I mean, my thought would be if, especially now with April, with that meeting, with the vacation in the middle.
So we
Maybe
can
we
consider
could-
the 23rd or the 30th,
I would say,
or
I think we should have a public, I mean, let's have public hearing on the 23rd and have that the 31st, 30th be a working meeting, if that's okay with everybody.
I'm not really comfortable with going to the public yet. I said that I'd like to have resume the working session before we go to the public again. I feel like we've had such a long hiatus. I'd like to kind of pick up where we left off before we go to the public. I think that's fair.
Lots, do you want to have a public, do you want to go to?
I'm very eager to hear from the public.
executive session.
No, it wouldn't be executive, but
Yeah, I would like to, as I stated earlier, I would like to have a working session, which we haven't had in several months, before we engage the public. Because I think there are some concepts that I would like to have broader discussions on. To your point, like, we need to talk.
Yeah. I think that makes sense, specifically, especially in light of Tom's comments about, hey, the public can't comment on what's not in the draft. So if there are things that need to be added to the draft before we get to the public, I think it makes sense to have at least one working session and then go from there. So maybe a May timeframe, but we can consider other dates beside a Tuesday as well, if we want to try to.
Commissioner Newman, can I just ask a process question? So I think that the suggestion that public comment on something that's already written down is a good one, but it's a hard one to abide by, that we need to keep it, maybe not just limit it to what's been documented, but this process really has two outcomes. One is to create a document. Second is to create consensus within the community. So as we, and this is always something I run straight to the document usually, but watching planners work, they work collaboratively with the community. So what's staff's suggestion on how to best strike that balance between engaging the community without getting bogged down? How many meetings should we have? How long should this take? You don't have to give me an answer now, but it'd be great to get some input from you. And then do we bring the consultant in at some point to give us feedback on some of the ideas? I'd really like to you're the professionals, you're excellent at what you do. I'd like to get some of your suggestions on striking the balance between getting input in order to build consensus and new ideas, and for us to reach some consensus. So if you could come back to us with a framework for doing that, that would be very helpful.
Yeah, I think that's going to be dependent on what issues in the commission's view are unresolved still that need to be worked out, because I think we do need the benefit of some discussion before we get to the public, and whether we tweak the draft or we go to the public hearing or have the public hearing and then revise a draft. I don't know that order is critical, but I think what we need a better understanding on how comfortable you all are with what's been presented thus far and what needs to be included and or changed, before we start to try to build that consensus, as you say.
And I just want to remind the commission as well, we've had three very robust public outreach sessions. So this started with the winter workshops before the pandemic, before we got shut down, right? So we did 3, really well-attended public outreach sessions on those. Then we did the survey with the consultant, and then we did the last public outreach that was at the school at Osborne Hill. So we've kind of taken the temperature of the general public who chose to participate with us to say, do you agree with because I will say that the draft goals that we developed were initially from those original winter workshops. What do you and the community want to see? And those are the ones that we did at SHU and Fairfield U and at Penfield. What are your concerns? What do you want to see, given that these are the areas that the state statute requires that we talk about when we think about what we're looking to do within the next 10 years, policy and goal wise within the town of Fairfield for conservation and development. So we did that outreach. Then we followed that up with the survey that we did because the pandemic happened. People's worldviews really changed a lot in terms of their focus on community spaces, wanting more multimodal, all of those things. So we did that virtual survey. Our consultant took that virtual survey and then incorporated those policies and goals within the document. Then we further kind of ground truthed those goals and policies at that last public hearing at that last public meeting that we did at Osborne Hill School, where we had representatives at each of those areas, which are now kind of our chapters, to talk to the public about, do you agree with this? Do you not agree with this? And that was the DOT survey, right? So to a certain extent, the public has kind of weighed in on those things that we identified as possible strategies and goals to move forward with within the next 10-year window. So, the question is, is there a lot more to add to that, considering that 10 years goes by really quick? I know it seems like it doesn't, but when you're talking about a POCD, this is a document that we'll adopt, and then probably in about 7.5 years, we're going to start revising it again because we have a 10-year statutory requirement to have it adopted every 10 years. So, this isn't, I would say that this isn't, this is still kind of a quasi-living document where at some point we have to say, we're good for now. And then we have to start doing the other work, which complements this, which is updating our zoning regulations in terms of its format, and then talking about those policy changes, those parameters for private investment, both for single family homeowners, for our, commercial developers who do mixed use, our residential developers who do larger residential, changing those parameters within our actual zoning regulations. So we still have a lot of work to do beyond just this document, and we have reached out to the public a lot. So, I think at a certain point, we have to kind of decide this is where we are now for the next 10 years, understanding that we'll start again in about 7.5 years.
There's gonna be no perfect document that everybody agrees on. I get it.
Of course.
Agreed. None of us will agree on it too. I get that, but again, I would like to have that working session, and I appreciate all the outreach. I know people have loved it and it's been engaging, so it's great stuff.
I know we had a lot of outreach, but once people actually look at this document, then you see in writing where the rubber hits the road, okay? And then you see what actually is going to happen. That's where I've gotten questions from people about, many changes from the current POCD from 2016, and also concerns about, things that we've brought up before, density, impact on enrollment, things like that. So I think the public has not had a chance to weigh in at all on this document, this draft. So I would like to have more rather than less public involvement in going forward. Now that we have a working copy, they can actually see, well, this is what it's going to look like. This is what's going to drive.
Well, I mean, we've all said that. I mean, I think
Without a doubt.
I don't think we have enough public comment.
We haven't had really any. I mean, we've had some, but it's been through
Not on this, though.
emails or the board. No, absolutely not. We haven't gone to public hearing with a draft document yet.
So your point is we've had a lot of engagement. That's been part of the process from the get-go.
Well, I hope that the commission understands that, in our talking to the public through those different activities, that's what's kind of generated the document to begin with. And absolutely, we are required to have public hearings on this, and that will happen, but.
Part one, but we need more, that's all, yeah.
Well, yeah, that's going to depend. It's entirely up to the commission, how many hearings, depending on what we hear initially. So
So let's shoot for a
working session later next month, probably later next month. And then we'll see where we are after that, with either additional working sessions or going to public hearing.
And I'm open to doing it not on Tuesdays too, if that's
I agree.
helps with others. I don't know.
I mean, listen, like I said, I don't mind doing public hearing and working sessions jointly. It may be a little messy, but I think to some extent that it makes sense as far as an efficiency standpoint, because at some point we're gonna get comments from us and comments from the public. Another document's gonna be generated and then public comment from there. So having said that, we can work on dates and stuff, but let's shoot with that general framework. And then again, get your comments together, even just for yourself, but even for the rest of the commission to, see where you want. Okay? Thank you, staff. Appreciate all.
Thank you.
And just to confirm, do you want some of our feedback?
Yes, absolutely.
That being our last item, I'll close the hearing on, we'll close the meeting.
Thank you.
Thank you, everyone.
That's a record.
I thought, but that's okay.
That never happens.
And it's a little. I know.
You're charging?
We're still recording.
Okay.
We have a lot
The
of.
microphone's on, the one on. Actually, are we recording? Sorry, I see that we are.
Yeah, so
Yeah.
even,